Morning. The committee will come to order. Today, the Small Business Committee will examine how small business owners in the digital technology industry use intellectual property protections to help their businesses and the issues they face when navigating the intellectual property process. Digital technology allows small businesses to sell their products and services all over the world. In fact, 84% of small businesses use at least one major digital platform to provide information to customers. Digital technology also plays a vital role in the American economy, and the United States is the largest technology market in the world. The tech industry accounts for approximately $1.6 trillion in direct economic value in the United States, and net tech employment accounted for over 7% of the overall workforce in 2017. As we learned from our hearing on intellectual property in May, intellectual property plays a vital role in protecting creative and innovative products and ideas both here in the United States and abroad. America's intellectual property is worth $6.6 trillion, and intellectual property intensive industries employ over 45 million Americans. Our nation's small business owners are essential to producing new, creative, and groundbreaking products and ideas that strengthen our nation's economy. In fact, entrepreneurs and small business owners have generated about 70% of new jobs over the last 2 decades, and small businesses represent about 96% of employer firms in manufacturing industries with a high number of patents. Intellectual property also accounts for 52% of all merchandise exports in the United States. However, the process for obtaining intellectual property protections can be daunting, even for the most experienced small business owner. It can also be very expensive to hire professionals to traverse the intellectual property process. Because of their limited financial ability, small business owners are vulnerable to their innovations being stolen, both here in the U.S. and internationally, which can be financially devastating. The FBI has found that intellectual property theft costs billions of dollars every year to America's businesses, and thieves are targeting small business owners and startups because of their limited abilities to fight back. To combat this problem, this committee unanimously passed H.R. 2655, the Small Business Innovation Protection Act of 2017, this past March, and I'm pleased to report that it passed the full House yesterday. This bipartisan legislation, which was sponsored by Mr. Evans and co-sponsored by Mr. Fitzpatrick on our committee, would leverage existing resources at the SBA and the U.S. Patent and Trademark Office to better assist small business owners and expand the agency's outreach efforts to provide small businesses with the resources they need to address intellectual property issues. Today, we will hear from experts on intellectual property and the digital technology industry on the role that intellectual property plays for this vital and growing industry. I look forward to hearing how intellectual property helps small digital technology businesses and what we can do to foster America's creative small businesses moving forward. And I would now like to yield to the acting ranking member, Mr. Evans, for purpose of making an opening statement.
Thank you, Mr. Chairman. Good morning. Digital technology has become a vital part of nearly every industry. Over the past 3 decades, the tech sector has created 23% more new businesses than the private sector as a whole. Technology innovation bolsters our economy, making IP protection a vital part of the process. Protecting the intellectual property rights for technology innovation can support long-term job growth, increase exports, and drive development. New business ventures rely on a system in which their ideas are protected. Intellectual property is a $6.6 trillion industry that accounts for over 1/3 of total U.S. gross domestic product. And small firms make up the vast majority of firms in intellectual property intensity industries. In fact, startups and high-tech hub accounts for more than 40% of new jobs each year. These businesses have an enormous stake in ensuring the continued growth of intellectual property. Patent protection helps innovators recoup the cost of research and development, capitalizing on their inventions, create jobs, and grow the economy. It is also essential to ensure the availability of businesses to ensure their rights to both at home and abroad. Doing so is critical to protecting American economy's interests. In 2016, Customs and Border Patrol received 1.3 billion of intellectual property rights infringement goods across our borders. This theft can have a deep impact on small businesses that may have limited time and resources. This is especially true among women, minorities, and other underserved business owners who already face obstacles obtaining IP protection and funding. More than 80% of patents do not include women. This gap is likely because of their unrepresentation in the science, technology, engineering, and math fields. GPD per capita could rise up to 3.3% with the inclusion of more women and African Americans in the initial stage of the process of innovations. Congress must address the inclusion of unrepresentative groups to allow for additional small business growth. This hearing will allow committee members to hear from entrepreneurs on opportunities for growth in the digital technology industry and to understand what additional measures are needed to ensure their long-term success. I thank our witnesses for being here, and I yield back the balance of time, and I thank the chairman.
Thank you very much. Gentleman yields back, and I'll now announce that if committee members have opening statements prepared, that they be submitted for the record without objection, so ordered. And I'd like to take just a moment to explain our lighting and timing rules. Basically, pretty simple. We operate under the 5-minute rule. You all get 5 minutes. We all get 5 minutes to ask questions, and there's some lights to assist you. The green light will be on for 4 minutes, and then the yellow light will come on, letting you know you have a minute to wrap up, and then the red line means stop. So you don't have to stop mid-sentence, but if you'd stay within those parameters to some degree, we'd greatly appreciate it. And I'd now like to introduce our distinguished panel this morning. Our first witness will be Frank Cullen, who is the Vice President of U.S. Policy at the U.S. Chamber of Commerce's Global Innovation Policy Center. Mr. Cullen directs the center's domestic programs in promoting and protecting intellectual property rights in both the online and physical markets. He has extensive experience speaking on intellectual property issues, and we welcome you here today. Our next witness will be Morgan Reed, who is the president of ACT, the App Association, a trade association representing over 5,000 app makers and tech companies. Mr. Reed specializes in intellectual property, security, privacy, connected health, digital trade, and business development. He also has experience as a coder and business owner and has testified before Congress in the past. And we welcome you here, Mr. Reed. And our third witness will be Christopher Moore, who is the Vice President for Intellectual Property and General Counsel at the Software and Information Industry Association, or SIIA. SIIA represents over 800 companies in the software and information industries. Mr. Moore acts as SIIA's Chief Legal Officer and Principal Spokesperson on intellectual property issues, and has appeared before legislative, judicial, and administrative bodies on intellectual property issues, including the Supreme Court of the United States. So we welcome you here, Mr. Moore, and I would now yield to the acting ranking member for the purpose of introducing our fourth and final witness.
Thank you again, Mr. Chairman. It is my pleasure to introduce Mr. Christopher Israel, Executive Director of the Alliance of U.S. Startup and Inventors for Jobs, a coalition of inventors, startups, and research businesses that depend on patents. Prior to his role, Mr. Israel served as the U.S. Coordinator for International IP Enforcement and also served as at the Commerce Department. He received his BA from the University of Kansas and his MA from George Washington University. I welcome Mr. Israel. Thank you, Mr. Chair.
Thank you very much. And Mr. Cullen, you're recognized for 5 minutes.
Thank you, Mr. Chairman. And also I want to thank the ranking member, Velasquez, for the opportunity to testify at this important hearing. The U.S. Chamber of Commerce's Global Innovation Policy Center is working around the world to champion intellectual property rights as vital to creating jobs, saving lives, advancing global economic growth, and generating breakthrough solutions to global challenges. The U.S. Chamber of Commerce is the world's largest business federation, and more than 96% of our member companies are small businesses with fewer than 100 employees. As members of this committee know well, small businesses employ more than half of all Americans, and the Chamber is proud to represent millions of these businesses. Intellectual property, or IP, as I think you all well know, is an umbrella term covering copyright, patent, trademark, and trade secrets. It's often the secret sauce that gives a new, up-and-coming company its competitive edge. The loss of that edge through theft or other appropriation invites unfair competition that can devastate even the largest company, much less a small one. The critical importance of IP was recognized in the Constitution, where Article 1, Section 8 Clause 8 provided that Congress shall have the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. Now, this set forth the fundamental policy approach that has undergirded America's rise to the largest economy in the world. This formula is straightforward. Allow authors and inventors to own the intellectual property rights over their creations and inventions, and they will have an incentive to create, invent, and distribute to the benefit of all. This formula is as true today as it has ever been. Yet any commercial project carries the risk that it will fail or not become commercially successful. And of course, there's the added risk that even if successful, copycats may attempt a free ride on the work of others and offer fake products at an artificially low price. This is precisely the form of unfair competition that IP protections are designed to prevent. As Steve Jobs said, from the earliest days at Apple, I realized that we thrived when we created intellectual property. If it weren't protected, there'd be no incentive for us to make new software or product designs. And it's worth noting that Apple, like so many other small businesses, started with an idea and the creative genius of two young inventors working in their garage. By allowing innovators and creators the opportunity to run a business on their talent and ingenuity, IP rights drive U.S. competitiveness and economic growth. The chairman noted the impressive economic numbers. The Department of Commerce estimates that more than half of our exports, $842 billion, and almost 40% of all U.S. GDP can be directly tied to IP-intensive industries. And for the past 6 years, GIPC has published an annual international IP index. As we look over the course of our report, we see one clear pattern. Strong IP environments tend to enjoy greater levels of research and innovation output. And as a top scorer in its overall IP system, the United States has a competitive advantage over other countries. Now, every market requires equitable rules, but an environment of overbearing regulation can strangle business growth, especially for small businesses with lightly and tightly limited resources. A marketplace that has no rules invites abuse and theft to the detriment of businesses and consumers alike. As former Fed Chair Alan Greenspan said, market economies require rules of law. A system of intellectual property protections is one of the reasonable rules that creates an environment of fairness and promotes innovation and job growth. Free trade agreements can also provide protections of IP rights for small business owners, creators, and inventors. Now, in the digital environment and the technology that accompanies it, we have seen a great enhancement of the ability of businesses to connect with their customers far beyond the reach previously thought possible. They have provided new media for creative expression and new tools for innovators. However, this technology can be a double-edged sword. While thousands of small businesses now have the opportunity to compete in the global marketplace, they are at risk of having their products ripped off by unscrupulous criminals. So one of the problems we have, as the chairman alluded to, is that most small businesses, when they start out, don't factor IP protection or an IP strategy into their business plan. They need to have education about these fundamental forms of IP protections and how copyright, patents, trademarks, trade secrets can really benefit them. Obviously, we understand that when you're doing business in the online environment and there are threats from counterfeiters, it not only affects a small businessman, but it also potentially affects consumers. So it's important that the brand that has been established in a new up-and-coming company is not undermined by either the theft or by subpar products being put into the marketplace by criminal elements. Because when that brand is really reduced in terms of its value, it hurts both the company and ultimately the consumer's access to new products. Obviously, I have additional information in my written testimony, and I welcome the committee's questions. Thanks again for this opportunity to testify.
Thank you very much. Mr. Reed, you're recognized for 5 minutes.
Chairman Chabot, Ranking Member Evans, and distinguished members of the committee, my name is Morgan Reed, and I'm the president of the App Association, a trade association representing more than 5,000 app makers and connected device companies in a $950 billion industry. The app economy employs 4.7 million Americans and is outpacing nearly every other sector of the economy. In fact, we have over 500,000 open jobs waiting to be filled. As our 2018 State of the App Economy report, which you all have, shows, smartphones are the single most rapidly adopted technology in world history. Device ownership grew from 0 to 3.4 billion people in just a decade. The broad reach of cloud plus mobile structure creates the conditions for rapid adoption and gives our member companies in all 435 congressional districts, including yours, access to markets around the world. Let's take a moment to dig into that, because it's easy for anyone to sit on the panel and say, well, we represent a lot of people, but let's give it some specificity. So Chairman Shabbat, in your district, we have Can Spinach Designs. My friend Andrew Savitz built a company there that's a design and development firm, but they've also built a cool mobile app that allows large companies to offer discounts and benefits to their employees that they can pass on to their family. Congressman Evans, in your district, we have Neat. Neat extracts key information from your receipts and documents and integrates it with popular accounting and business software. Congressman Luketemeyer, in your company, in your district, we've got CSPI. They do online banking services, and they tie in the ability to take that picture of your check and they tie it back to your mobile app. That's the company that helps make that all possible. Congresswoman Adams, in your district, we have my friend Douglas McDowell, who runs a company called SentryOne. They enable Microsoft data professionals to monitor, diagnose, and optimize the products in the environment and in the cloud for mobile. Congressman Schneider, in your district, we've got Pathfinder. They're a health company, one of my favorite technologies that incorporates mobile tech, and they're doing it for both small and large companies. Congressman Kelly, Next Gear Solutions, great product. They've built a mobile app that helps people who go in and solve, if you've had a house that's had a fire or a flood, they're building the mobile app that allows the on-site professional to take pictures, instantaneously take notes, figure out how to resolve the problem, fix your house, get your family back in as quickly as possible. Congressman Marshall, we've got Mediadime Solutions that builds a ton of mobile apps. They're in the Kansas First. They do website and graphics as well. I have folks for everybody here, but as I'm looking at my clock, I figured I'd shorten it up a little bit and say that's the reality of the world we're living in. We're here to talk IP. That IP is not just in Silicon Valley. It's in every single one of your districts. And a big part of that comes from the IP protections that are available. Our member companies not only rely just on copyright, but also patents, trademarks, and trade secrets. And I'd like to thank all of you for your support of the Trade Secret Acts that passed last year. One of the things to understand is, how does it matter? Software is especially dependent on copyright. I know members of the committee here are well aware of music and movie piracy, and that anti-copyright voices claim the problem is with the business model of copyright holders. For my members, they've heard, if you provide the app for free, nobody can steal it. I'm here to tell you today that free isn't cheap enough. No matter what business or pricing model our members choose, piracy still occurs. You might be thinking, how is that even possible? How do you steal a free app? Well, I'll tell you. One of our members had one of their apps was downloaded 160,000 times for their free app, and yet none of the revenue came to him. Well, free apps are usually monetized through advertising. In this case, a pirate took his app, moved it to a different ad network that fed the money back to the thief, not our member. To make matters worse, our member's app featured video components, so every time it was viewed through the pirated version of the app, our member was charged by his hosting service. Essentially, he was paying for the privilege to be robbed. Beyond copyright, I want to talk for a moment about the importance of patents to our companies and their beneficiaries. We have members who have patents, but all of our members depend on patented technologies. I know many of my panelists will be talking about the USPTO, but I want to talk a moment to talk about standards. Over the past 20 years, the United States has led the way in protecting IP and preserving fair, reasonable, and non-discriminatory licensing terms for standards that allow companies to make innovations. Standards create the foundation for technology advancements and interoperability competing products, while still maintaining fair, reasonable, and non-discriminatory paths to compensation. We need to preserve a strong voluntary standards system to ensure that entrepreneurs can create the next great innovation on top of those great standards. Small businesses benefit the most from an effective standard system because it enables them to specialize and go head-to-head with big companies. We urge members of the committee to support the current voluntary standard system and the balance it strikes for IP rights holders. I thank you for the hearing and look forward to your questions.
Thank you very much. Mr. Moore, you're recognized for 5 minutes.
Thank you, Mr. Chairman. Mr. Chairman, Ranking Member, and members of the committee, on behalf of SIAA, thank you for the opportunity to appear today. SIAA is the principal trade association of the software and information industries. We represent over 700 companies that develop and market software and digital content for business, education, and consumers. IP is at the core of SIA's mission, and the association was founded on advocating for and enforcing its members' intellectual property rights. That priority has remained, even as we have grown to represent 800+ members, including software and cloud companies, financial information and database providers, educational technology companies, and online publishers. Some of our member companies were born digital. They created and designed their business model for the internet. Others either have or are transitioning from an analog existence to an online one. Some members fund innovation by selling subscriptions. Others fund it by advertising. Others fund it by selling copies. For all of our members, intellectual property and the integrity of that property has always been at the core of what they do, and it's growing in importance for all of our member businesses, especially the small ones. The pace of innovation is accelerating. Patents continue to be granted in record numbers. It took over 200 years for the United States to issue 9 million patents. It took 3 years to get to 10 million. That growth trend is reflected all over the country. For example, according to PTO statistics, in your home state of Ohio, there were approximately 108,000 utility patents granted in the years between 1963 and 2002. Between 2003 and 2015, about half that time, there have been 150,000 utility patents granted. According to statistics compiled by the Copyright Alliance, Ohio's residents have registered about 76,000 copyright. There seems to be an IP deluge, not a drought. And that flood of innovation has been good for software and technology businesses of all stripes. In your home state, Mr. Chairman, again, these are according to Copyright Alliance stats, the software industry supported nearly 80,000 jobs and contributed $13 billion to the nation's GDP. And that's bled through to R&D. Since the Supreme Court's software patent decision in 2014, R&D spending for software grew at a 27% rate, faster than the growth of all other industries, at least between 2014 and 15. For software and services, there are estimates that the R&D spending will grow to be about 24% of all R&D by 2020. And since 2014, the number of jobs created by software developers has increased 14%. That is a very convoluted and probably over-statistical way of saying that Congress should be taking a bit of a victory lap. The IP laws created by Congress are the engine that drives innovation. And from the standpoint of SIA members, whether you're talking about copyrights, trademarks, patents, or trade secrets, that engine is purring. These laws are working to incentivize invention and the creation of expressive works while preventing acts of unfair competition against businesses small and large. From the patent standpoint, the AIA, combined with the Supreme Court's decision in Alice, has helped to mitigate the still existing problem of patent litigation abuse. Bills like the one that you passed yesterday and your Big Data and IP Act also help. SIA opposes rolling back either of these improvements, especially given the deluge of patents and growth in the software industry that is occurring under existing law. With respect to copyrights, the substance of the law is working well, but administrative improvements would improve small business access, specifically by modernizing the Copyright Office. On the whole, it is our view that current law is working very well. Thank you again for the opportunity to appear before you today, and I look forward to the committee's questions.
Thank you very much. Mr. Israel, you're recognized for 5 minutes.
Thank you, Mr. Chairman. I'd like to thank you and Ranking Member Velasquez, Mr. Evans, members of the committee for this opportunity to be here today. It's an honor to participate in this important hearing focused on the role of intellectual property in supporting small business development and growth. I'm here on behalf of the Alliance for U.S. Startups and Inventors for Jobs. USIJ is a coalition of over 30 startup companies and their affiliated executives, inventors, investors that depend on reliable patent protection as a foundation for their business. It's difficult and perilous to start a new company from scratch. For companies built around a new invention or committed to solving a complex problem, it also requires investors with a very strong appetite for risk. The U.S. patent system is designed to incentivize and reward this risk. Unfortunately, over the past 15 years, we have seen the foundations of the U.S. patent system eroded by court decisions and changes in U.S. law. This has resulted in the U.S. falling from number 1 to number 12 in terms of IP strength, according to the U.S. Chamber. We believe there's a very strong correlation between the patent system and the willingness of entrepreneurs and investors to take risks on big breakthroughs and complex problems. USIJ is releasing today the results of a study we conducted on the trends in venture capital investment from 2004 to 2017, which I've included in my testimony. I will touch on a few of the key conclusions and offer some recommendations on how Congress and the administration and PTO can strengthen the U.S. patent system to better support startups in key tech sectors. To be clear, not all small businesses and startups depend on patents for their success. Many do not, and some even find patents a burden. But companies that invest heavily in R&D to create breakthroughs in strategically critical technologies do depend on patents to protect them from predatory behavior of would-be competitors anxious to copy any new product or technology once it is proven workable. As the U.S. patent system has slipped from the strongest in the world to number 12, we have seen the elimination of injunctive relief for patent owners, significant limitations on the ability of inventors to even obtain patents in key areas of life sciences and software, and a procedure at the U.S. Patent and Trademark Office that allows an open-ended opportunity for anyone to challenge any valid U.S. patent multiple times and often without any business reason for doing so. So how is the market reacting to all of this? As you might expect in some ways. Even though total venture capital in the United States has increased nearly fourfold over the last 15 years, the portion committed to small businesses in important technology sectors has declined significantly. In 2004, 21% of all venture capital funding in the United States went to the following strategic patent-intensive sectors: internet networking, wireless communications, semiconductors, drug discovery, and medical devices. In 2017, only 3.2% of venture capital funding in the U.S. went to these sectors. So who are the beneficiaries of this relative decline in funding for strategically critical technology? In 2004, 11% of all venture capital in the United States went to the following sectors: social network platforms, business-to-consumer technologies, financial services, and software apps. By 2017, 33%, one-third, of all venture capital in the United States went to these sectors. While the latter group has certainly led to some interesting products and services, created a lot of jobs, and led to some very well-known and ubiquitous global companies, these are not typically the sectors that are generally investing heavily to push the outer boundaries of science and technology to remain competitive in a global market. These declines are fairly shocking unless one believes that the U.S. can maintain its technological leadership with minimal investment in startups that are working in the areas of new drug discovery, networking equipment, cybersecurity, AI, medical devices, biotech, semiconductors, computer hardware, and a host of other core industrial sectors, while one-third of the funding for new companies in the United States goes to apps, social media, and online shopping and banking platforms. The good news is that there are some specific things Congress and the U.S. PTO can do immediately to revitalize the U.S. patent system for inventive small businesses. These include passage of the Stronger Patents Act. I'd like to thank Ranking Member Velasquez and Mr. Norman for co-sponsoring that piece of legislation, providing statutory clarity for patentability of life sciences and software inventions under Section 101 of the Patent Act. In addition, PTO can make some needed reforms to change its post-grant review procedures. We strongly support the pending rule change to discontinue use of the BRI standard for claim construction. Patent owners should be allowed reasonable opportunity to amend their claims during a post-grant review proceeding, and USPTO should address serial attacks on patents held by small companies by larger competitors working in collaboration and with surrogates. This has become a major problem for technology startups. Mr. Chairman, I appreciate the opportunity to participate in this hearing and look forward to all the questions.
Thank you very much, and I'll now recognize myself to begin the questioning. I'm recognized for 5 minutes, and I'll begin with you, Mr. Cullen. In your experience, how much information on intellectual property do startups and small business owners typically need when developing their companies?
Well, at the very least, they need to understand which type of IP is going to be most applicable to their business. So education about what can benefit them in terms of their business plan and their product is essential. Obviously, there are costs associated with IP protections, and that has to be factored into their business plan as well. These are widely divergent. For instance, the Copyright Office, for $55, you can get a copyright, but it's much more expensive if you're going to seek out a patent. You're talking thousands of dollars. So you have to really figure out what is the appropriate IP for you, what the terms are in terms of how long that IP protection will last, whether or not it's going to be relative to your business domestically or abroad, and whether you, of course, are going to do business in other markets. So education about all the types of IP that are out there and what's most applicable to your business model is probably the most fundamental thing you need to do.
Thank you very much. Mr. Reed, I'll turn to you next if I can. What are the best practices to combat online piracy and counterfeiting for app developers? And also, how do you fix the problem that you mentioned where, the fellow had his app, a free app, not only stolen, but then he's getting charged for every one of its uses, and the thief is getting the advertising revenue as well.
Well, I think there's a couple of things, and I want to take a piece of what Frank just opened with. We always tell the story when we talk to our small business members about IP, and we say it this way. If I walk up to you and I say, who in your office handles your intellectual property? You always get a shrug or I'm not sure. And if I say to the business owner, who in your office is in charge of birthdays? They always know who's in charge of birthdays. And what we say is, your IP needs to be at least as important as who's in charge of birthdays on the calendar. So build a binder, start collecting everything, your employee agreements, your anything else that you're doing. What are your vendor agreements? One of the stories we have is one of our members lost $3 million because one of his vendor agreements said that any work that he did for them was owned by the company that he was doing the work for. It's a completely reasonable thing. He didn't know it was in his agreement, cost him $3 million on acquisition. So at a minimum, the way I would address your question is, make IP at least as important as birthdays. Know who handles it, knows who's in charge of it, and how you're collecting it. On to your larger question on what do we do to protect. We've actually seen that there have been some real market improvements by the platforms here in the United States. Apple in particular has done a really good job of allowing our members to contact them and let them know about an application that's stolen or pirated or contains pirated content and get on top of it. Globally, we still have a larger problem. We see that as an area of real concern. Around the world, jailbreaking phones or sideloading applications is much more common than it is in the United States, and that's a real avenue. Unfortunately, it's also an avenue for 97% of the malware that's out there on mobile devices as well. So quick answer, platforms are doing a fairly good job. They can get better. We also work with TAG on the advertising revenue. The acronym escapes me. It's the group for the advertisers that works on preventing click fraud and advertising fraud. But it's a problem that we're all working on, and we're working on together because it's costing us millions of dollars.
Thank you very much. Mr. Moore, I'll turn to you next. How important is it for software companies to have intellectual property protections, and which protections would you consider to be the most important for your members?
Well, it's critical. I think there are two, I think, that are most important, and that would be copyright and patent. And we have been historically extremely involved in enforcing our members' rights against pirates. And I think, to riff off of what my friend had just got into, there is another angle to piracy now, because a lot of what happens sometimes is that your relationship with a software company is far more interactive than it used to be, say, 15 years ago. It's no longer the case where you load a CD into your computer and then never think about it again until you need something better. Instead, what happens is there's an ongoing relationship with the software provider. When that software is altered and pirated, what happens then is the creation of consumer protection problems. That there's intellectual property harm, of course, if you're trying to sell copies and someone is ripping them off, then you have a revenue problem, but that problem is internal to you. There's an external problem now with people whose data or other information could be compromised. The second thing is with respect to patent protection. Our members Our members have patents. They have many, many, many patents. Their primary concern is that the system, from a defensive standpoint, prevent bad patents from being enforced. And that has two components, at least, maybe more. The first component is on the front end, to be ensured that applications are properly examined and good patents are issued. The second is after issuance, if the PTO makes a mistake, that there be a procedure by which those patents can be efficiently challenged. We believe that procedure exists under the AIA.
Thank you. I think I'm going to have to cut you off there because
Okay.
my time's expired. And
Yep,
I
yep.
apologize for not getting to you, Mr. Israel. The gentleman, ranking member, gentleman from Pennsylvania, is recognized for 5 minutes.
Thank you, Mr. Chairman. Mr. Israel, women, racial minorities, and low-income individuals seem to be significantly underrepresented in the innovation ecosystem. This is extraordinarily alarming as these individuals will face challenges in other areas of business as capital. What steps should Congress take to help narrow the gaps?
Thank you, Mr. Evans. It's a great question, and we'd look forward to and welcome any opportunity to work with you and your colleagues to address it. We've got some really groundbreaking women members of our organization who've spent years and years building and creating companies. So there certainly is a huge opportunity for progress here. We think, just kind of fundamentally getting back to the first principle of ensuring that the patent system and the IP system, we're removing as many barriers as we can to get as many creative entrepreneurs into the system as possible. I think working with major universities and research institutions, there's such a great source of diversity and tremendous ideas and entrepreneurs. So I think we've talked about and would look forward to developing some ideas, maybe working with larger research institutions and universities in every state in the country to help accelerate some of that integration of women and minority entrepreneurs and match them up with the venture capital and support that they need to build great companies.
To you, Mr. or to Ms. Collins, specifically, what can Congress do? Tell me what you think Congress can do.
I'll give you a couple of examples. As I said in my opening testimony, we have 500,000 unfilled jobs.
Right.
Unfilled, not prospective, not hopeful, jobs that we don't have people for. So specifically, we see there are two items that we've been working on. One is we've got to get the K through 12 education around this area earlier on. We'd love to see a grant program, even a low-dollar one, that helps to open the door so that when my members who want to donate time to educate students have a pathway into a school. Right now, when you knock on the door to say, hi, I'm here to teach computer science, there's not even a person to talk to. You talk to the vice principal and they say, well, we don't have any way to even incorporate you into our curriculum. So there's the potential for a small, low-dollar grant from the Department of Education to help those schools bring in the entrepreneurs, my members and Chris's, into those schools. The second area is my membership. We recently had 50 CEOs come to DC. Many of them visited you. And I did a survey of the room, and I said, how many of you are currently employing people who do not work in your office? 100%. We had 100% of my members currently have employees that are not in their main office. And so that gets into issues around broadband access and how do we better utilize spectrum like TV white spaces so that we can actually have people in other places. I testified in another hearing with a gentleman from Mississippi where he was training coders in Mississippi. And I said to him then, and I'd say it now, if you train the people and give them the talent, if they've got broadband, I'll employ them. So when you ask the question of what Congress can do, we need better help on the education side, and we need to make sure that spectrum is available for broadband in places that don't naturally have it. They're either rural or low income, and let's make that change.
Thank you, Mr. Evans. And as my colleague said, it's a great question. Certainly I echo what my colleagues have said on the panel. Education is key, and we certainly commend the committee for its work in passing important legislation this week, which provides resources to USPTO and more resources to agencies such as the SBA and others to develop programs that can reach out to underserved individuals who are trying to start businesses and really have the opportunity to employ Americans. So from our standpoint, we very strongly support legislation that provides those resources, whether it's in education or it's in agencies such as the USPTO or Small Business Committee, and we think we need to see more of that.
I'm going to start with you real quick. I only got like 51 seconds, and this is for the panel. We've heard conflicting information regarding the health of our nation's existing patent system. How do we reconcile these views and balance the needs of truly innovative firms on both sides of the issue? 31st.
Well, we believe that innovation is driven when you have a strong IP system. It helps support it and drive it. And clearly, you need to have clarity in the patent system, and you need to have a patent system that really is going to work for the inventors and the folks who really have to be able to assert those rights. From our standpoint, we think that predictability and a clear patent system is most important.
We all, I think, given the 8 seconds left, as I said in my opening testimony, we want to make sure that the standard system is preserved and the intellectual property within the standard system both correctly rewards the people who invent it, but also makes it a pathway to be used by everyone.
Thank you, Mr. Chairman.
Thank you very much. Gentleman's time's expired. The gentleman from Missouri, Mr. Lukemeyer, who is Vice Chairman of this committee, is recognized for 5 minutes.
Thank you, Mr. Chairman. And Mr. Reed, appreciate the shout out to CSPI. I actually know those gentlemen personally. We actually are a customer of theirs. They're a true American dream story. There are 3 guys who started out as Burroughs office repairmen, and Burroughs decided to contract out the repair work, and they became their own little company to contract with Burroughs, and then he went off and developed this product. And now they're nationwide and mega millionaires. So it's, I'm in the wrong business, obviously. But thank you for that. One of the questions I've got is with regards to our the administration is concerned right now with trade, and one of the things that's involved in trade is protection of intellectual property. And so can you, I know Mr. Reed and you talked about it a little bit, and Mr. Cullen, you talked about it a little bit in your testimony. What are other countries doing to protect their inventors, their copyright stuff that is different from ours that we could use to help us, help our people? And how do we protect our people here from what's going on in the international little world of espionage here to go take our intellectual property where I think we probably, I don't know what the percentage is, but I'm sure we do most of it here in this country versus everybody else.
Well, thank you again for the question. It's an excellent one. Obviously, more needs to be done across the board and globally. America does lead. Our IP index that the Chamber releases shows quite clearly the benefits of a strong IP system. Now, you've seen different types of IP protections in different types of countries. Some of the things we do here in the United States vary a little bit. We have in the past looked at different ways to protect copyright in the online environment. Other countries have taken stronger measures to protect copyright in the online environment, such as in Great Britain and in other markets.
Should we be taking a lead like that, or are they off the charts with the way they're doing it?
You know, we're not advocating legislation. What we're saying is that there's still a significant problem that needs to be addressed.
Okay.
Some of this can be addressed through voluntary agreements between businesses, and some of this can be addressed through simply educating consumers about what other legal choices are available to them. But when it comes to actual IP protections, one of the things we stress is that in our index, you'll see the clear benefit to having an overall strong IP system that covers the broad range of IP, and we would suggest that countries that have that type of system in place will be the most innovative.
Mr. Reed?
I'll echo mostly what Frank said. I think one of the interesting parts that you saw all of us look at each other when you asked that question, because it's an interesting formation of a question we hadn't really thought about. Because the United States is such a leader on intellectual property, on trade, we tend to be the people in the room saying, how do we do the most for Americans? And the rest of the world tends to be saying, well, you know, let's find some soft edges. Now, that's not always true, as Frank pointed out. In Europe, we see that there are some systems there where they are definitely adopting a stronger position. I think that the part that makes really interesting is how do we execute on what you described, but make sure that we're not running into a situation where we create barriers. Because the reality is that the one place the United States has a trade surplus with every nation in the world is in IP. And so we're always tentative about adopting the ideas of other countries if they're only adopting that kind of protection in order to squeeze out American competition. So we sit in an interesting catbird seat when it comes to IP. We're better than everyone else at it, and we want to stay that way. And so figuring out how do we continue to innovate is going to be a critical part of it. And let's not make sure we fall into a case where they squeeze us out of opportunity.
Yes,
Just one last point, free trade agreements can also play a significant role with strong IP chapters in terms of aligning IP protections.
I think that's one of the reasons where the administration is looking at these trade agreements is for the, you know, especially with China trying to steal everything, and also for them to actually come in the back door of other countries. I mean, that's one of the reasons we're trying to get the EU and Canada and all those other countries at the table to be able to talk to them and say, to talk to them about, hey, you know, we need to have you help us protect our industries and our IP. And it seems to me that that's a big part of it. I'm about out of time here, so I'll yield back to balance my time, Mr. Chairman.
Thank you. The gentleman yields back. The gentlelady from North Carolina, Ms. Adams, who's a ranking member of the Subcommittee on Investigations, Oversight, and Regulations, recognized 5 minutes.
Thank you, Mr. Chairman, and thank you, gentlemen, for your testimony and being here today. Mr. Cullen, as we seek to strengthen the patent system to better protect our inventors in the global marketplace, I believe it's equally important that we also strive to eliminate the gender, racial, and income gaps that currently exist here in the U.S. As a first step to address the gender and race gap in patenting, would it be helpful for the SBA, USPTO, or other relevant federal agencies to examine the gender, race, and income gaps in patenting and their impact on the American economy, small business development, and entrepreneurship?
Thank you, Congressman, for that important question. And I agree wholeheartedly that anything we can do to help quantify that situation would be beneficial, not only to those who are seeking opportunity, but also to our economy at large. I can tell you without reservation that the new director of the USPTO, Andre Iancu, has embraced, I think, a lot of novel approaches to strengthening both the USPTO and the patent system. And I'm confident that if you brought that idea to his staff and his team, that he'd be willing to take a look at that, and I think it's a very important initiative.
All right, thank you very much. Mr. Israel, a recent study found that obtaining a first patent plays a huge role in helping startups secure venture capital and other financial investments. In fact, startups that obtain their first patent are 33% more likely to obtain venture capital funding than startups that don't receive a patent at all. It's especially true for startups that had not already attracted significant investment prior to receiving the patent, companies with inexperienced founders, and startups located outside of the geographic areas that traditionally attract investors like Silicon Valley. So can you comment on these findings and give us your opinion about what Congress can do to ensure that the patent system is accessible to underserved populations of entrepreneurs?
Thank you, Ms. Adams. It's a
Mr. Israel.
great question, and those statistics are well known and borne out in reality, and we can certainly provide specific examples of them. It is, as you say, it is a key indicator of the ability of a young company, particularly in a research and development intensive sector, life sciences, heavy technology, whether or not they're going to be able to secure the type of funding they need if they've got a strong patent portfolio. The types of companies that we work with and we see close up are the types that need, you know, anywhere from $100 to $250 million sometimes of venture funding to see their way through that initial idea all the way through to getting it to market and becoming a viable company. So if we are, as a nation, in the business of leading in these big areas that require a lot of heavy research and development, we need a strong patent system that maps up to it and that allows those inventors to get the resources they need. So as I noted in my testimony, I believe we're actually falling short in a few key areas. When we've seen it in the trend lines in venture capital and where it's going, in the inability of companies to get the patents that they need and secure the funding that they need. So we think it's essential that Congress step in and take up the question of patentability under Section 101 of the Patent Act in areas like software and life sciences. The courts and some recent decisions have created some uncertainty there. We think it's critical that the Patent and Trademark Office, and I know Director Iancu is considering a number of reforms, look at some changes to correct how easy it is, frankly, for patents to be challenged, particularly by large companies against small startups who have patent portfolios. So this post-grant system at PTO, we believe, has become slanted towards and much more easy for large companies to target small companies and, frankly, take their intellectual property out and mitigate its impact in the marketplace. So the trend lines are there. The evidence is very clear that if you have a strong patent portfolio, you have to have that if you're going to address investors and expect them to put a risk and take a risk with you and your company. That's a very true thing, and we think it's also true that unfortunately we've slipped in some of the areas that allow those small companies and startups to protect their intellectual property, to give those assurances to the investors that they're working with.
Thank you, sir. Mr. Chair, I'll yield back.
Thank you very much. Gentlelady yields back. And the gentleman from Virginia, Mr. Bratt, who is the chairman of the Subcommittee on Economic Growth, Tax, and Capital Access, recognized 5 minutes.
Thank you, Mr. Chairman. Thank you all for being here with us today. I had a breakfast meeting today on China and North Korea, and had an expert speaker come to us. We're all debating, playing 8-dimensional chess with many complex issues at the global level. And I said, what's the most serious, right? The South Sea Islands, the military buildup, the tariff piece from China, or intellectual property? He said intellectual property, most significant issue. And he said, look at what we're exporting to China, right? And we're losing our competitive advantage in intellectual property, et cetera, relatively speaking, not absolutely. And so I just want your take. Today we're discussing kind of micro-level issues on theft, privacy, et cetera. But if you can each just weigh very briefly in on the connections you see between the global economic, competitive environment and the micro issues. I mean, are they related? How are they related in your minds? I'd just love to hear the experts weigh in on the relationship between the Chinese stealing intellectual property. Does that manifest itself in what we're talking about today? And if so, how do you see that? And we can start with Mr. Cullen, work on down.
Thank you, Congressman. I appreciate the question. It has a huge impact. Has a huge impact on small businesses who are having their products counterfeited, our folks who are having their songwriters who are having their music pirated. So from our standpoint, we certainly have concerns about what's happening with the theft of intellectual property. Almost 90% of counterfeited goods come out of China and Hong Kong. So this has a huge impact, not only on these companies, but also on the jobs they create. So we're deeply concerned. GIPC has a dedicated program working with China. I'd like to point out that one of the things we have to look at is the overall situation in China, not just how it's impacting us and how we can help them move from essentially a counterfeit economy to a different type of model. And so from our standpoint, we're going to continue to work with our counterparts in China. There are some successes in law enforcement and other areas, but it's very tough sledding.
I want to take a page, since he said a lot of the key things. I think one of the things that's important for everyone here to understand is that my smallest member is an international player. If I think about Hannah Dare in Tampa, Florida, she's a tiny developer shop, and yet she has tens of thousands and even hundreds of thousands of customers around the world, including in China. So one of the key elements that plays in this, all of what Frank said is critical, but we have to remember that what we're really looking for is how do small businesses have access to that market? How do we help China get to the point where we're selling into them? Because they want our apps. We know they want our apps because they're stealing them when it happens. But the point is there's demand, there's value, there's creation that exists there. And so I think what we're really looking for is how do we move to the state where the United States and our innovators and our small businesses are able to compete and provide products, because that's the real growth possibility.
Just quickly, without trying not to repeat what everybody else said, because I think we would be in agreement with all of it. I think what you see is where you have, if you have particular economies or particular cultures in which those property rights are not respected on a micro level, on a macro level, you're going to have problems. And that's exactly what's happening. And there are many tools that you have to use to change that perception. But that's how we, I mean, it's a big problem with a lot of moving parts, let's say.
I'm not speaking through. Sorry, guys. The gentleman this morning said we're not pushing hard enough. China's also using our banking system to launder money through, right? And we punched them a couple times, small banks, and we have tremendous leverage there. The tariff, some of the tariff legislation right now is actually written through the section having to do with intellectual property. It's not just a tariff policy. It's through intellectual property, and I don't think that's gotten out. So if you all can weigh in and give us some input as a committee in writing following this, what the levers that would be most effective to help the industry and help American workers, that'd be great. And finally, yeah, Mr. Israel, sorry.
No, and Congressman, appreciate that, and having spent some time with the U.S. government working on this issue, I'd welcome the chance to work with you. I think two fundamental things are true at a very high level, right? I think, as I've stated, I think over the past decade or so, we have in a number of ways systemically weakened the U.S. patent system. Some of it's been in pursuit of wringing out litigation abuses and patent trolls, but the reality is that we have a weaker patent system today than we did a decade ago. I also believe at a very fundamental level, the Chinese, through their China 2025 strategy, which you probably spoke quite a bit about this morning, are strategically and tactically targeting dominance in the most critical technology sectors that exist today. Artificial intelligence, robotics, life sciences, you go down the list, computer networking, wireless. Those are exactly the sectors that the United States needs to have a very strong patent system in order to incentivize the best and brightest entrepreneurs we're going to need, the type of investments we're going to need, and the type of strong companies that we're going to have to create to compete with the Chinese, who are coming at us with everything they've got. Not all the good ideas and not all the best breakthroughs are going to come from big, large, multinational corporations. A lot of them, most of them, are going to come from small companies with creative ideas that need a lot of resources and need strong patents.
Gentleman's time's expired. Anybody else? The gentleman from Iowa, Mr. King, is recognized for 5 minutes.
Thank you, Mr. Chairman. I appreciate this hearing and the witness's testimony. I'd first turn to Mr. Israel and ask, you said that our patent system protection is less than it was 10 years ago, and I agree. Could you identify why that is the case?
Thank you, Congressman. We've talked about a few of them this morning. As I noted, there's been some court cases that have made it extremely difficult and very unpredictable to get patents, for instance, in the software sector and the life sciences sector, and there's some work going on to examine that.
If I could, I'm particularly interested in your view on the change that was made in patent law to shift from first to invent to first to file. Mm-hmm. How has that impacted our patent protection?
Well, I mean, it's brought us in line with global norms, but it's certainly put more pressure on small inventors to demonstrate to the patent office that the validity and the strength of their patent. I would say, in addition to that, a very big burden and challenge and obstacle that's been placed on small companies in particular is the post-grant review, so kind of the after-the-fact challenge system that exists at PTO, that once you have a valid patent as a company or an inventor, you're pretty much, there's an open-ended ability for anyone to come forward from anywhere in the world, really, and challenge those patents almost endlessly. And
so the scenario works out like this. If you're a garage or a home shop inventor, you generate the idea, and then you don't have a very good system to go ahead and apply for the patent. And so the chance of a leak and a theft of that intellectual property being filed by a larger company that's got the network to do that happens more often than it did before. Mm-hmm. And then, even if you file, you're still subject to the litigation coming back at you from the other way. So it advantages the large operations that have the administrative network and the skill sets, and disadvantages the small. Would that be a fair analysis?
We believe that to be true, that oftentimes you'll see small companies that have breakthrough technologies. As soon as they're ready to go to market, they're targeted by larger competitors in the post-grant review process at the PTO.
Thank you, Mr. Israel. And I turn to Mr. Cullen, and I noted that you said we need to help China in particular move from the counterfeit economy. And I like the phrase counterfeit economy. They have a substantial counterfeit economy, and there are a lot of small things along the way as I listened to this, but I didn't hear any big ideas. I heard a little law enforcement here, I've been over there to beat on the Chinese and talk to them about what are you actually doing, and they assure us that they're bringing civil actions against the IP pirates that are active over there. And I say, hey, that's fine. What happens? Well, we fine them. And then once you fine them, who collects the money? Well, the government does. And they put it in their other pocket because a lot of those are government-owned companies. And I says, anybody getting any criminal charges against them? Well, one. Is he in jail yet? No. Or maybe not, was more like the question. It wasn't a very answer. It wasn't a straight answer. So I'll bring it to this. Sitting there in the third city meeting in China, and it happened to have been in Beijing, it occurred to me that each one of those meetings each was exactly the same script. And sometimes it isn't that inscrutable. It came to me that their business model was, we're going to steal your intellectual property, and then as a cost of doing business, part of their overhead is to wine and dine Americans that come over there to complain. But they never intend to do anything about it because they're getting rich off of the theft of our IP. In fact, it is a multi-billion-dollar strategic effort to steal the creativity of America. And those numbers range someplace between $250 billion a year and up to $600 billion a year, depending on whose estimates are there. So from that meeting sitting over there, I'm sure the Chinese hacked my email off my BlackBerry, but I wrote it sitting at the table, and it was this: draft a bill that directs the U.S. Trade Representative to conduct a study to determine the value of intellectual property theft stolen by the Chinese and apply a duty to all Chinese products coming to America in an amount equivalent to recover that loss, plus an administrative fee, and then distribute those proceeds to the rightful property rights owners. That's H.R. 1048. Now I want to ask you, Mr. Cullen, do you believe your organization could support such a bill? I'll let you hear it.
Well, I appreciate that question, Congressman. And creative approaches to these problems are what we need. I certainly can't commit that we'll support the bill. More than happy to take a look at it. We have a lot of engagement with China, and I agree with you. This problem is so vast that we need to see some tangible results. Our companies, as Morgan referenced, want to do business and access that market. But if we're having our intellectual property stolen, it puts our companies at great risk. So appreciate the creative approach, but I can't say we'll support the bill.
I'd like to ask you and Mr. Reed to take this idea back to your people and contact me with a response on this. And I'm happy to have a meeting and have a discussion to expand this further because it's gone too far. And Hollywood and Nashville didn't want to touch it 10 years ago. But now the president has this in his hands, so we need to get behind him and solve this problem. There's too much theft going on of IP, and it's time to do something about it. So I'd ask you to do that. Would you say yes, each of you gentlemen?
We appreciate the opportunity to commit to it.
Thank you. And let the record show that Mr. Reed did as well. He nodded his head and he smiled. I think he smiled. Okay. Thank you very much, gentlemen. I appreciate it. Mr. Chairman, I yield back.
Thank you very much, Mr. King. And rather than go through the closing statement that I had, I'll just conclude with a real short one. Put me on that bill. All right. Very good.
Done.
All right. Thank you very much. And we want to thank the witnesses for their excellent testimony here today and the great questions from both sides of the aisle, I think, on all this. Has been very helpful. I would ask unanimous consent that members have 5 legislative days to submit statements and supporting materials for the record without objection, so ordered. And if there is no further business to come before the committee, we're adjourned. Thank you very much.